Good afternoon. I'm Professor Joseph Singer. I'm here on the faculty and want to welcome you to this event. The Civil Rights Act of 1964 is, in my view, one of the most important pieces of legislation in the history of the United States. I've written myself many law review articles about it, and it's very central in my own thinking about democracy and property and the rule of law, among other things. And we wanted to have this panel because we thought it was important, and the dean thought it was important to mark the 50th anniversary of the passage of the law. I say mark the passage of it. I originally had written down to commemorate it. There's lots of things that are really great about the statute, but there's also some limitations to it, both in terms of the coverage of the law and its effect in the world even today. So we have 4 faculty members that are each going to reflect for about 15 minutes each about the statute. We're going to start with Professor Kenneth Mack, and then Randall Kennedy, and then Mark Tushnet at the end, and then I will speak at the end. There'll be time for questions after we speak. This is being recorded right now, so if you have questions, come up and talk at the microphone so your questions can be heard by the microphone and be part of the recording of the event. So go ahead, Professor Mack.
Hi. Thanks, Joe Singer, for organizing it. It's a pleasure to be here to talk about the 50th anniversary of the Civil Rights Act of 1964. I'm going to talk just a little bit about the historical background to the statute. Where did it come from? What did it do? Why was it so controversial? As many of you know, it was enacted after the longest Senate debate in American history at the time. Essentially, it took a year to get the statute through. Lots of activism from the grassroots to the White House and everywhere in between. Churches, civic groups, Congress, 2 successive presidential administrations. It was a controversial and, in many ways, I'll argue, revolutionary piece of legislation. So I'm going to talk just a little bit about why it was so controversial. Why did people fight it so long and hard? Why did people fight both against and for it so long and hard? By putting it in a little bit of a historical context. So as all of you know, the statute was enacted on July 2nd, 1964. Everybody knows a little bit about it. The popular image of the statute is of the signing ceremony with President Johnson and civil rights leaders, preceded by things like the March on Washington. And I'm going to tell a little bit of a longer story of the Civil Rights Act of 1964. How did we get there? But just even in the short version of the story, the preceding events, as many of you know, the 64 Act was originally a piece of legislation introduced by the Kennedy administration in early 1963. The original version of the statute was fairly tepid by the standards of what civil rights activists were looking for at the time. It got stronger. It became the statute we know because of grassroots activism all over the country. Specifically, what really got the thing going were the Birmingham demonstrations of 1963, which many of you know. Martin Luther King and others controversially sent school children into the streets who were subject to mass arrests. It put civil rights on the front pages of the newspapers. It put pressure on President Kennedy, who had been thus far very tepid on civil rights, and it put pressure on him to come out with a stronger bill. Now, lots of things that we know the Civil Rights Act of 1964 for still weren't in the bill, even when it got stronger after the Birmingham demonstrations. So a lot of other things happened to make it the bill, the statute we know today. One of the things that happened is, of course, the March on Washington in the fall of 1963. Everybody knows the speech by Martin Luther King that's the highlight of the March on Washington. But what most people don't know was that the official goals of the March on Washington were this. It was the March on Washington for jobs and freedom, both things. The official goals of the March on Washington were for equal access to employment, housing, public accommodations, education, voting, for school desegregation, and for a full employment program run by the federal government. These were the official goals of the March on Washington movement. And, you know, as we'll see in a second, the Civil Rights Act of 1964 spoke partly and incompletely to these goals. What's in the 64 Act? A bunch of things that we know, and a bunch of things that we don't really know so well today, but were really important in 1964. I'll just highlight a few of them. Title I was about voting, because one of the issues in 1964 was access to the ballot. And now, one of the issues in 1964 was proof of qualifications that you were a proper voter, and how proof of qualifications that you were a proper voter was, everyone understood, a way to substantively make it harder for certain people to vote. So Title I of the 64 Act actually dealt with how one proves that one's a proper qualification to be a voter. Title II is the public accommodations provision, which is quite famous to all of us. Non-discrimination based on race, religion, and national origin, race, creed, religion, national origin, and access to public accommodations. Title IV helped devote additional federal government resources to school desegregation. Title VI is something that is kind of all over the media right now. Title VI had to do with federal funding, requiring non-discrimination based in programs that receive federal funds. Title VII was our has become our most famous employment discrimination statute, and Title VIII again dealt with voting. So this is what the statute did. Everything from voting rights to public accommodations to school desegregation to non-discrimination in programs that receive federal funds. And all of these things were incredibly controversial as of 1964. And the fact that we got a statute that did all these things continues to reverberate through our society today. So let me tell you just a little bit about how we got there. How did we get to the Civil Rights Act of 1964? What's the long history? What's the long legislative history of the statute? Well, you know, I just sort of told you a story that begins at the beginning of 1963, but of course that's not the real story. The real story goes back decades. People were pushing for things that wound up in the Civil Rights Act of 1964, basically from the beginning of the 20th century. The most important organization that did it was, of course, the NAACP, the National Association for the Advancement of Colored People, founded in 1909. Most of us know the NAACP primarily for its school integration work, but it did a lot of different things, including, from the 1930s forward, pushing for non-discrimination in many aspects of employment. In the 1930s, the NAACP got involved in what was called the Don't Buy Where You Can't Work program, where in African-American communities around the country, there were protests and boycotts against businesses that didn't sufficiently hire Black workers. And during World War II, of course, the NAACP got involved in the effort that succeeded in convincing President Roosevelt to create the Fair Employment Practices Committee, which was the federal body that enforced non-discrimination in the defense industry during World War II, the first federal employment non-discrimination enforcement mechanism in American history. After the war, civil rights groups all over the country pushed for a permanent FEPC without success, but this was part of the advocacy that went into the '64 Act. People have been talking about and pushing for a federal employment discrimination program since the 1930s in one way or another. The second part of what made the '64 Act sort of part of a longer and more complicated story had to do with the efforts of civil rights activists to expand the ability of the federal government to regulate aspects of the economy. As you have to understand, part of the controversy over the '64 Act was, did Congress have the power to enact such a statute? Could Congress regulate private employment relations? At the beginning of the New Deal, the answer would have been basically no. But by '64, the answer was, well, maybe yes. And civil rights activists were part of that story. As many of you know, that the New Deal, one of the results of the New Deal extension of the ability of the federal government to regulate the economy was a reconceptualization of what Congress could do under its Commerce Clause power. And as many of you know, the '64 Act was enacted primarily under Congress's Commerce Clause power, and you couldn't have gotten to the statute without the New Deal. And in fact, many of the civil rights activists who were involved in the NAACP first began to talk about this during the New Deal. People like Charles Hamilton Houston, William Hastie, Harvard Law School graduates, a guy named John P. Davis, who nobody's ever heard of, but sort of took Felix Frankfurter's public utilities seminar at Harvard Law School and went down to Washington, D.C. and became this sort of hard-charging advocate trying to enforce a non-discrimination mandate in New Deal programs. Because the New Deal was, many of you should know, was incredibly racially discriminatory. Civil rights activists began to think about employment discrimination and think about the power of the federal government to regulate employment discrimination really in a sustained way in response to the race discrimination that was written into core New Deal programs, right? So employment discrimination goes all the way back to the 1930s. The idea that there is an expanded federal power to regulate the economy and to enforce a non-discrimination mandate goes all the way back to the 1930s. And also, one of the reasons the Civil Rights Act of '64 was so controversial was because many of the things it regulated were traditionally regulated by state law. It's a reworking of core elements of federalism. When you think about public accommodations, employment, schools, voting, actually, all things that are in the '64 Act, to make them subject to federal regulation was a revolution in our ideas of federalism. That goes all the way back, of course, all the way back to the early 20th century, all the way back to the NAACP's advocacy around anti-lynching. The NAACP began to push for an anti-lynching statute in the 1920s, and of course the big debate about anti-lynching is, well, could you enact a federal statute that regulated something that seems like a state law crime? And in fact, so, before you could get to the '64 Act, what you had really was sort of decades of advocacy and decades of activists, lawyers, many of whom were associated with this law school, who worked very hard to expand the contours of federal ability to regulate things, federal ability to enforce a non-discrimination mandate. And all of that preceded the Civil Rights Act of '64. Okay, I'm only going to say I'm going to say one more thing, but I'm a law professor. There's always one more thing. But I'll say maybe one more thing preceding about the Civil Rights Act of '64. The things that it regulated were not just Southern problems. They were Northern problems. So in fact, a lot of the things that happened in 1963 and 1964 that helped shape the form of the enacted statute that we know today were happening in the North. There were school boycotts in Chicago to protest, school segregation and unequal resources in the North. There were violent construction protests in Philadelphia to protest the exclusion of black workers from city school projects in Philadelphia. And this is a little bit later, but as many of you know, that when Martin Luther King first comes north to Chicago to bring his movement north, he encounters violent resistance. He encounters mobs that want to sort of tear him limb from limb because, of course, segregation was the rule in the North as well as the South. So one of the things that made the statute so controversial was because it was really trying to revolutionize not just what was going on in Birmingham, Alabama, but what was going on in Chicago, Philadelphia, Boston, all over the country. It was trying to do it through an aggressive assertion of federal power to do these things. And it was doing it building on both legal precedents, social activism, and social activism that extended back decades to the beginning of the 20th century, and that took basically an entire year to enact the statute, because at the time, everybody thought it was revolutionary, and it was. Thanks.
Thank you very much. I'm going to make 3 points about the Civil Rights Act of 1964. Point 1, the Civil Rights Act of 1964 stemmed from a major defeat for the civil rights movement. One of the most dramatic parts of the Civil Rights Revolution had to do with an effort mainly led by students to challenge the idea that privately owned places of public accommodation could legally practice racial discrimination. That was an established part of the law. Now, in 1960, let's say, 1960, there were many parts of the United States where you had state laws that prohibited privately owned places of public accommodation from engaging in racial discrimination. There were some 30 states in the early 1960s. There were 32 states in the District of Columbia that prohibited racial discrimination in places of public accommodation. But half the black population, of course, lived in the former Confederate states, and those states certainly did not have laws prohibiting racial discrimination in privately owned places of public accommodation. So it was perfectly fine for hotels and motels and restaurants to openly say, no colored people allowed here, or colored people served in the back, in the rear. That was perfectly allowable. Well, civil rights activists challenged that. They thought, many of them, that just intuitively, they thought this cannot be, this isn't right. And they sat in. February 1, 1960, the 4 freshmen, North Carolina A&T, who sat in, challenged this. The fact is that ultimately they lost. Their lawyers lost. Their lawyers, when these young people were put in jail for disorderly conduct, for trespass, when they fought their convictions, their lawyers went into court and said, these convictions are wrong because, among other things, there ought to be a federal constitutional right for people to be served in places of public accommodation free of racial impediments. That's what they argued. they lost. The Supreme Court of the United States never was willing to go that far. Now, the Supreme Court was sympathetic to the protesters and tried to protect them in various ways. And one of the most important things that the Supreme Court did during the first half of the 1960s was to extend the ambit of the 14th Amendment by creatively dealing with the state action problem. Of course, the 14th Amendment, according to the Supreme Court of the United States, only corrects state action, not private action. And so the court enlarged the idea of state action. Let me give you an example. One of my favorite cases from the Civil Rights Revolution, Peterson versus City of Greenville. It's one of my favorite cases because City of Greenville is in South Carolina. I'm from South Carolina. The lawyer who represented the students in this case, Matthew Perry, was a neighbor of my relatives in Columbia, South Carolina. I used to steal figs from Matthew Perry's backyard. This was a case, City of Greenville, students sat in at a lunch counter. They were arrested. The question was, well, was their arrest legitimate? The Supreme Court of the United States invalidated their arrest and said, listen, the problem here is that this is unconstitutional, their arrest. It's unconstitutional because there was a ordinance in the city of Greenville that prohibited people of different races from being served food together. Now, the privately owned, the manager of the place where they were arrested said, well, forget about that ordinance. I'm in favor of racial discrimination. So even without the ordinance, I would have excluded the blacks. But the Supreme Court said, no, doesn't matter what you would have done on your own. The fact that there was an ordinance, we will say that that's conclusive proof that the state was dictating racial discrimination. Well, the court did that. The court did various things to try to aid the demonstrators. But one thing that the Supreme Court was never willing to do was to say that there was a federal constitutional right to be served at a privately owned place of public accommodations. Now, in 1883, the first Justice Harlan had said, as a matter of national citizenship, people ought to have that as a federally guaranteed right. The Supreme Court of the United States was never willing to go that far. So it's important to remember that the Civil Rights Act of 1964, at least or an important part of it, stemmed from a defeat. Okay, second, the 1964 Civil Rights Act also represented a tremendous victory. Where was the victory? Well, in the 19th century, the last federal Civil Rights Act was the Civil Rights Act of 1875. And the Civil Rights Act of 1875 had a provision in it that prohibited racial discrimination in places of public accommodation. The Supreme Court struck that down in 1883 in the civil rights cases. The Congress did not pass another Civil Rights Act from 1875 until 1957. In 1957, the Congress passed the Civil Rights Act. In 1960, the Congress passed the Civil Rights Act. You might say to yourself, well, why isn't anybody talking about those acts? What happened to them? Why aren't they commemorated? They're not commemorated because they didn't amount to much. And the reason they didn't amount to much, in fact, the reason why the white supremacists in the Congress allowed the Civil Rights Act of 1957 to be passed, the reason why they allowed the Civil Rights Act of 1960 to be passed was because they had been rendered impotent. They had been watered down so much that the segregationist position was, oh, let these pass. Let these pass. We can live with this legislation because it didn't amount to much. The Civil Rights Act of 1964 represented the first time that the white supremacist bloc in the United States Congress fought against federal civil rights legislation, tooth and branch. I mean, they fought it hard, but they lost. And that was the true significance of it. They fought Strom Thurmond, et cetera, et cetera, et cetera. The segregationists, they fought hard against it, but they lost. And as Professor Mack mentioned, it was the longest collective filibuster in the history of the United States Senate. They lost that, and that marked an important turning point in the struggle over civil rights in the 1960s. And when you say, you know, they won that, they won. Was there a concession? Was it total victory? No, it was not total victory. It was not total victory, because then you ask the question, well, on what basis was the 1964 Civil Rights Act predicated? Was it predicated on the idea of equal justice for all? That's what we all think, right? You know, equal justice for all? No. The primary justification for the 1964 Civil Rights Act was the Commerce Clause of the federal Constitution, the idea being that racial discrimination imposes a burden on the economy. So even though the Congress was actually trying to do right, even though it was trying to push some degree of racial decency in our society, they couldn't be completely candid and straightforward about what they were doing. They had to dress it up in a way that actually lowered the emotional and theoretical and political and philosophical, credit that this act should have received. Third point. You'll notice from my discussion, I've been focusing on a particular title in the 1964 Civil Rights Act. I've been focusing on a part of the act that people don't really talk about much today. I bet that you could go through, I think that you could go through Harvard Law School and maybe not deal at all with Title II, unless you took a course from Joe Singer, but to a very large extent, people do not talk about Title II of the 1964 Civil Rights Act. It's, in fact, a title that, within 3 weeks, you could master it totally. You could read every case within 3 weeks. It's a title that's never been amended. It's a title that actually, in terms of case law, you could read it pretty quickly, all of the case law. It was the 1964, the Title II, the Public Accommodations section of the 1964 Civil Rights Act. There was some degree of fighting and squabbling about it when it was passed, but that went very quickly. It has been extremely successful. There was very little resistance to it. You compare it, for instance, compare it to the Voting Rights Act of 1965. Compare it to Title VII of the 1964 Civil Rights Act. A lot of fighting over employment, a lot of fighting over voting. With respect to public accommodations, not so much. It's been very successful. And that itself is sort of an interesting thing. Why is it so successful? Now, some people make the claim, well, it was successful because actually it didn't amount to much. That's what some people say. In fact, let me read you one of the greats of the Civil Rights Revolution. The great Bayard Rustin said the following: "What is the value of winning access to public accommodations for those who lack money to use them?" There have been some who've said, well, this was a mere symbolic victory. Mere symbolic victory, the right to, sit at the lunch counter and buy a hamburger. What good is that right if you don't have a job, if you don't have the financial wherewithal to purchase the hamburger? I think this is a wrong way of thinking about it. There was a reason why people were willing to die over Title II of the 1964 Civil Rights Act. And when I say die, I'm not trying to be, sort of dramatic. People did die over Title II of the 1964 Civil Rights Act. It was by far the most controversial provision. And it seems to me, and this is my final point, that we ought to be a little bit more careful when we refer to certain things as being, quote, merely symbolic. As Oliver Wendell Holmes once said, we live by symbols. Symbols are extremely important. If we go back to February 1st, 1960, and those 4 freshmen who went and demanded the hamburger, just suppose the manager had said, listen, fellas, we'll give you 2 hamburgers if you just accept your hamburgers in the back. We'll give you more than everybody else gets. They didn't want more than everybody else got and had to go in the back. The symbolism meant something. Imagine Rosa Parks. I mean, you could take the position, well, Mrs. Parks, you're on the bus. Does it matter whether you're in the front of the bus or the back of the bus? The bus is going to the same destination. Is being at the back of the bus, that's just merely symbolic. The fact of the matter is that symbols count. This was substantive. It was substantive symbolism, and it was a great thing that the people, again, largely young people, who fought for this were successful in pushing us a little bit further down the way toward decency over something that sometimes people now refer to as mere symbolism. Thank you very much.
I'm going to continue with Professor Kennedy's discussion of the public accommodations section title of the Civil Rights Act, noting, in my defense, maybe, that I teach about it in my First Amendment course. So, my general topic is something I call the continuing libertarian objection to the public accommodations title. And when I say continuing objection, what I mean to say is that at the time of its adoption, there was a libertarian objection to the statute, and today there is a libertarian objection to the statute. On the latter, I'm not going to say all that much about anything specific, but you can look up the scrambling that Rand Paul has to do in connection with his views about the public accommodation sections of the Civil Rights Act. I begin with the story of Lester Maddox. Lester Maddox owned a restaurant in, I think it's Atlanta, Georgia, called the Pickrick Restaurant. And he was a Democratic Party politician and activist and ardent segregationist. And he said that if any of the students from, I think it was Emory University, the black students from Emory University, came to his restaurant to try to do a sit-in, he and his staff would attack them with axe handles, which became, the axe handles became his symbol in politics. I think he called them, these were the picks of the Pickrick Restaurant, like big toothpicks, I think the idea was. And as a result of his, in part as a result of his vehement opposition to the public accommodations section, he eventually became governor of Georgia, immediately preceding, of all people, Jimmy Carter. But so he made his political career. on the basis of opposition to Title II. Now, what was the nature of his opposition? So when in constitutional law courses we study Title II, we do so in connection with the Heart of Atlanta Motel case, which upholds the constitutionality of Title II on the basis of the Commerce Clause. But Lester Maddox didn't care about the Commerce Clause. He didn't deeply care about the Commerce Clause. I mean, to some extent, there was a states' rights component to the defense of segregation. But what Maddox cared about was essentially, in highfalutin terms, a libertarian objection. That objection actually was articulated most dramatically by then Professor Robert Bork, who wrote a now infamous column piece in the New Republic, in which he described the principle of Title II as a principle of unsurpassed ugliness. And the principle that he was identified as underlying Title II was that that the government could the government had the power to force one person to associate with another person. The association would be in the form of providing commercial services to, but Bork said, not wrongly, that as a matter of classical common law, people were entitled to choose the others they wanted to transact with, subject to, it got fancier as you had to develop the argument, subject to some exceptions for, again in Bork's version, for common carriers who, he said, were in essentially, or the people who took his position said, were essentially a position of monopolists. So in a market where there were competitors, transactors could choose their counterparties. And Title II, actually in Title VII as well, were inconsistent with that idea, and that idea rested on the libertarian presupposition that people are entitled to decide who they want to associate with. So the Commerce Clause objection was not hypocritical, but it was the vehicle for carrying the more significant, I think, libertarian objection. Now, with the enactment of the Act and its upholding by the Supreme Court, controversy over the public accommodations provision basically died down, as Professor Kennedy suggests, but it's revived more recently, and the libertarian objection now takes the form not of Commerce Clause based, but to the form of an objection predicated on the right of expressive association. So in two significant Supreme Court cases, state courts said that our state law banning discrimination in places of public accommodation required that, in one instance, the St. Patrick's Day Parade in Boston, and in the other, the Boy Scouts of America, make their facilities available to gays and lesbians. And the court in these two cases said that the organizers of the parade and the Boy Scout Association of America had a constitutional right of expressive association that prevailed against over the state law public accommodations laws. It's worth noting that these interpretations of the state law public accommodations law were, one could say, pretty aggressive, but as a matter of constitutional doctrine, the fact that New Jersey and Massachusetts adopted these aggressive interpretations shouldn't have any bearing on the constitutional analysis. So now we have a right of expressive association that we now know can prevail over public accommodations laws. Now, so what do you do with that? Well, the first thing you do is to say, and this is in the literature in the immediate aftermath of Dale in particular, we don't have to worry about things like Title II, because the right of expressive association in Dale and Hurley was recognized in connection with non-commercial activities. And any commercial activity would not plausibly be able to claim that it had a right of expressive association to exclude African American patrons or as we'll see more significantly in the modern context, gay and lesbian customers. But what about the commercial, non-commercial distinction? Well, the Hobby Lobby decision of last term places the commercial, non-commercial distinction under pressure. I don't want to say that it cracks it, but it places it under pressure. What Hobby Lobby says is that as a matter of statutory entitlement, corporations, for-profit corporations, are entitled to claim the protection of the Religious Freedom Restoration Act. But in the course of explaining why that's so, Justice Alito wrote the following: "A corporation is simply a form of organization used by human beings to achieve desired ends. An established body of law specifies the rights and obligations of the people," underlined, "including shareholders, officers, and employees, who are associated with a corporation in one way or another, when rights, whether constitutional or statutory, are extended to corporations. The purpose is to protect the rights of those people." So it seems to me that that language, at some level, dictum in Hobby Lobby, is now available to use for a Lester Maddox type commercial operation, who Maddox would now have to say, I am a proud segregationist and operating my business in a way that visibly excludes blacks is an expression of my segregationist views. And that at least gets off the ground after the cases I've described. But with respect to race, there's another response, which is that everybody agrees that the right of expressive association can be overcome if the state has a compelling interest served by overriding it, and eliminating racial discrimination is a compelling interest. And so here again, from Hobby Lobby, the government has a compelling interest in providing an equal opportunity to participate in the workforce without regard to race, and prohibitions on racial discrimination are precisely tailored to achieve that critical goal. Okay, so that deals with Lester Maddox, but it actually doesn't deal with the contemporary libertarian issues, which involve denial of services in some instances to women, and much more significantly, denial of services, commercial services, to LGBT people. And what's significant there is that the formulation is compelling interest. So that's language that's associated with race discrimination. It's not associated with legislation implicating gender or LGBT discrimination. And so again, I think Hobby Lobby provides the resources to revive the libertarian objection in the form of a right of expressive association. And finally, I want to talk briefly about called the pure libertarian argument. And this is, actually it's developed in a piece by Richard Epstein in the Stanford Law Review. And it is a response to Bork, or it's a way of explaining why Bork was wrong. Because you have to, if you're living in the world today. You have to explain why Bork was wrong to cite this principle of unsurpassed ugliness. So what Epstein says is, and this is connected to some of the cases that Professor Kennedy described as well, what you had in the segregationist South in 1964 was essentially state-created monopolies in the provision of services at places of public accommodation. The underlying image is that the state wouldn't let a proprietor who wanted to provide services on a non-discriminatory basis to do so. Now, that wouldn't deal with the proprietor in Peterson, who said, yeah, there's this ordinance there, but you repeal it, I'm going to discriminate anyway. That's, if you want to put it that way, it's either my preference, that's the expressive association, or it's my business model. But the contemporary libertarian view somehow says that the existence of state-based segregation somehow created state-based monopolies that prevented essentially unwilling discriminators to follow their own preferences. Now, that monopoly was broken. I mean, take that point of view, and then that monopoly was broken by the Civil Rights Act. And now there's plenty of competition. And so the libertarian objection, the pure libertarian objection would go to the extent, and this again ties to something that Professor Kennedy said, to the extent that the harm that we are worried about is the denial of service to African Americans or LGBT people. Once you have competitive markets, they are going to be able to purchase services at basically competitive prices once the monopoly is broken. And therefore, the libertarian would conclude, the underlying principle of choosing the people you want to transact with reemerges as the governing rule. And so in markets that have become competitive because of the Civil Rights Act and because of social change of various sorts, there's no need for a statutory prohibition on discrimination, and such a prohibition violates the libertarian presupposition. Now, it's important to note, and this is the last thing I'll say, that the constitutional argument that I developed about the right of expressive association actually, I think, has some force in some predictive kind of way with respect to gender and LGBT people, not with respect to race. But the pure libertarian objection does applies to race as well. Indeed, it might even, Epstein sort of says it might even be better as to race than as to gender and LGBT people, because the market opportunities for serving African Americans are so widely dispersed that, to the extent that the concern is denial of services, again, at competitive prices, that concern is just absent once the monopoly disappears. Thank you.
So I have a couple points I want to make. First, I do believe, as I said before, that the '64 statute was one of the most important pieces of legislation in U.S. history. I think as Professor Kennedy said, it had a really dramatic effect in the world in terms of promoting equal access to public accommodations. I do think it's important to note that there remains discrimination in places of public accommodation in the United States, and there's actually quite a lot of it. A student of mine 1 year ago was not allowed into a club with two of his friends, and was asked why, and was told because he was Asian. He asked to see the manager. The manager said the same thing. Incredibly upsetting. He came to see me. I explained that he could call the Mass Commission Against Discrimination. They had to decide whether to involve themselves in that respect, and they decided not to because of wanting to focus on their studies. Several years ago in Massachusetts, right across the street from the State House, there were undercover police officers that went to get coffee. There were undercover police. And there was a policy that you paid for the coffee when you got it or before you got it. They apparently gave coffee to 6 or 7 white police officers and then asked the African-American police officer to pay before he would get the coffee. He asked why he was being treated differently than the others. They found out that he was an undercover police officer. It was embarrassing to them. There was proceeding against the place. There were alumni of Harvard University several years ago who were here for an alumni event and went to a club downtown in Boston. And when the club saw so many African Americans in line, they decided to shut the club because they thought there were gang members trying to get into the club. On top of these local examples, if you look up the law, Professor Kenny's right, there's almost no cases interpreting the Civil Rights Act of 1964, Title II. There are quite a few cases interpreting the 1866 Civil Rights Act, which the first part of it says every person has the same right to contract as is enjoyed by white persons, is it, or citizens? It's white persons, right? That act was thought for 100 years to apply only to state action, but that changed in the US Supreme Court opinion in 1968, which said that it applies to private action as well as public action. There were about 6 different Supreme Court opinions that were quite restrictive in terms of interpreting civil rights protections in employment and in other areas. And Congress passed a statute in 1991 amending the 1866 Civil Rights Act to make absolutely clear that it covers private discrimination and that it also covers terms and conditions of contracts. Despite that, here's a problem with the way the law now works. I looked up Wikipedia this morning to see what it says about the 64 Act, and it says that it prohibits discrimination in hotels, restaurants, gas stations, and places of entertainment. Those are listed in the 64 statute. And it says, and all other public accommodations engaged in interstate commerce. That's false. There's a short list in the 64 statute. It's hotels, restaurants, gas stations, places of entertainment. The Interstate Commerce Act prohibits discrimination of any kind in interstate commerce, in trains and planes and that kind of thing. For you to interpret the 64 Act to cover something like a retail store, you would have to read the list as illustrative rather than exhaustive. And so every year in my property course, I have students try and figure out how to make that argument. What's the counter argument? What's the right way to read the law? You have to read the exact language, read the language of what comes next. There's an exception. Private clubs are not regulated. You're allowed to discriminate based on race in private clubs within the meaning of the private club exemption in the 64 Act. It's possible to argue that the list is illustrative, but the only federal court that's addressed the question has said that the list is exhaustive. The Supreme Court has never addressed this issue. I think the chances that they would say it's illustrative are close to 0. I mean, maybe I'm wrong about this, but I don't think they would say it's an illustrative list. If you want to make a claim that you've been discriminated against in a retail store, the other possibility is the Civil Rights Act of 1866, either the one I mentioned about the same right to contract, There's another one, which is dear to my heart because I'm a property law guy. The next section, section 1981, says every citizen, not every person, every citizen shall have the same right to acquire, hold, lease, sell real property as is enjoyed by white persons. So, and it includes real and personal property. So going into a store to purchase personal property, to me that's a right to acquire personal property. So I would think that both the right to contract and the right to purchase personal property would be implicated. There's a problem with this, however, which is, as Professor Kennedy explained, there was a public accommodations law in 1875 which prohibited discrimination in hotels and restaurants and places of entertainment. If the 1866 Act was a public accommodations law, why was the 1875 Act even necessary? It's a little hard as a statutory interpretation matter to come to that conclusion. On the other hand, federal courts have in fact held that the 1866 Act does require retail stores to let people in without regard to race. The Supreme Court has never affirmed that, but every federal court that's addressed it has said the right to contract doesn't mean if you can find someone willing to contract with you, we'll enforce it. It means that, but it also means the store has to let you in because the right to contract means the ability to actually go in the store, offer money for the shirt, and have them actually sell you the shirt. So the federal courts say that it requires them to let you in the store, and it requires once you give your money, they have to, take your money and give you the shirt. What happens in the middle, racially discriminatory surveillance, following people around the store because of their race, insulting people, saying terrible, terrible things to them while they're in the store, refusing any service that's provided to white customers. A few courts, maybe 4 federal courts, have said that the right to contract includes the right to be treated equally with white customers, and that terrible treatment that people have gotten violates the 1866 Act. But the majority of courts, and quite a few of them now, I think probably, at least a dozen and maybe a dozen and a half courts have said that behavior while you're in the store is not covered by the 1866 Civil Rights Act. I think that's a terrible interpretation of the act, and I've written a law review article explaining why it's incorrect, but it's the law right now. It's a majority of courts say there is actually no federal remedy in a retail store. If retail stores are not covered by the 64 Act, which seems to be what the courts say, and if the 1866 Act doesn't cover it, there is no federal statute that prohibits racial discrimination in treatment while you're in the store. What other remedy could you possibly have? Well, you would look at state law. So I wrote an article about the history of this doctrine many years ago at this point. At that point, there were 10 states that did not have state public accommodation laws that regulate retail stores. I think the number now is about 5. I haven't looked at it recently to see exactly what the number is. There's a law review article from 2011 that says the number's 5. So in 40 or more states, you would have a claim under a state public accommodations law to full and equal enjoyment of a retail store. In a few states, however, there is no state statute that prohibits this type of discrimination. So the issue that Professor Kennedy raised at when he was talking about it, there is not a federal constitutional right to be treated equally in a retail store. There is still no federal constitutional right to be treated equally in a retail store. And in probably 5 states, unless there is a common law right. So I've written an article saying the states in those states should recognize a common law right to access retail stores without discrimination. The only state in the country that's done that is New Jersey. These states, the ones that allow this discrimination, have not done that. Unless there's a common law right and unless there's a constitutional right, then racial discrimination in treatment while someone is in a store is still not illegal in a few states. The worst one, I have to say, is Mississippi. And every year I'd ask if I have students from Mississippi because I want them to go back there and get this statute repealed. There is in Mississippi an anti-public accommodations law passed in 1956. It's Mississippi Code section 97-23-17. It is still in effect today. It says any business can refuse service for any reason. That means it is the law in Mississippi that a retail store can refuse to treat someone with respect because of their race while they're in a retail store, unless there's a constitutional right to be treated equally without regard to race when you're in a retail store. I'm not a scholar of the state action doctrine. I think it's ridiculous, and I don't understand it, and I'm not going to try and understand it. I am a scholar of property law, and I've written some maybe fanciful but maybe not so fanciful articles that refer to the provision of the Constitution that I think very few constitutional law people teach about, which is there are two provisions that say there shall be no titles of nobility in the United States. Congress is not allowed to give any titles of nobility. The states are not allowed to confer any titles of nobility. Because I teach property law and I teach our property as coming from a reaction against feudalism, to abolish feudalism. So the state of New York, 1787, had a statute abolishing feudal tenures. Many of the states had equivalent types of things, either through common law or statute. In order to have the type of property rights that we recognize in a free and democratic society, we had to abolish feudal tenures. We had to regulate contracts to prevent the creation of any feudal tenures. We want people to be free and independent and equal. We have no lords and we have no commoners in the United States. I see this not just as not giving titles, but I've interpreted this as an equal protection clause before we had the equal protection clause. That I understand the Titles of Nobility clause as saying that we are a nation that treats every single person as free and equal. And that, in effect, if you have a state statute like the one in Mississippi, which effectively allows the existence of a racial caste system in some form, I would hold that unconstitutional. I would even hold it unconstitutional under the Titles of Nobility clause. That's pretty wild, but that's actually how I sort of see it. And part of it has to do with my theory of property. Property is not just about keeping, it's about getting. And again, the way the federal courts have interpreted the 1866 Act, they've said everyone has the same right to contract as white persons. Again, that could be interpreted as just saying, like children don't have the ability to contract. If a child makes a contract, it's not enforceable in court unless the parents ratify it. Married women before the 1860s didn't have the capacity to contract. They would enter a contract, not enforceable unless the husband agrees. One interpretation of the 1866 Act is that it removes disabilities from African Americans. If you can find someone willing to contract with you, we'll enforce it. But the federal courts have said it goes beyond that, and it says you have the right to force people to enter a contract with you if the only reason they refuse to contract with you is because of your race. That's the uniform interpretation of the federal courts in the sense that they have to let you in the store. It makes no sense to me to say they have to let you in the store and they have to sell you the shirt, but in the meantime, they can prevent you from trying it on. Right? That to me makes no sense. I think it violates the terms and conditions provision of the Civil Rights Act of 1991. But that's the federal court interpretation. If that's what the federal courts say the statute means, there is still a live issue about whether the Mississippi statute should be held to violate fundamental constitutional rights to be able to participate in the marketplace without regard to race. So that's. So we have time for questions if there are any, and if you want to ask a question, come over to the mic so you can be heard.
Hi, thank you. I'm Pat Tomato, I'm a 1L. And when I think about public accommodations in the 60s, maybe it's a caricature, but I think about the way the economy in the United States was changing at that time. If you're a fan of Mad Men like me, you notice a lot of the clients are companies that maybe hail from a particular region, but they're trying to take their brand national, and they're trying to be all over, and a lot of them are consumer-facing brands. A lot of what people think about national brands now is it takes out some of the charm out of the community. Something is lost in the process if everything is IHOPs and McDonald's. But if one of the things you lose is racial discrimination, maybe good riddance. So my question, I guess, is in the legislation and the implementation. Where was the National Chamber of Commerce, the national business community? Were they silent? Silent, but kind of hoping this would pass? Because you could actually make a business expectation stability argument for it. Why have to run your national business two different ways, one discriminatory, one free and equal? Or were they, kind of dragging their feet?
I don't have an answer to your specific questions or what was the National Chamber of Commerce's position. I know that many business owners were nervous, opposed to the Civil Rights Act of 1964, mostly because markets don't work the way that the version of the one version of the libertarian objection that Mark Tushnet talked about posit. Lots of whites didn't want to associate with blacks, and that was true all over the country. So if you were a business owner, what you were more concerned about in '64 is that if you integrated, your white customers would leave. This is true, sort of the context that we know a little bit better here. Law firms, major corporate law firms. There are no black lawyers working at these law firms before 1970. A lot of the law firms would say, we personally are not discriminatory, but our clients are. We just can't hire a black lawyer because no clients will accept them. So to the extent the business community was anywhere in '64, it was opposed to most of what was in the statute, largely for those reasons, although I can't name specifically the Chamber of Commerce's position.
Just some of the national retail chains were, I think, silently relieved at the enactment of the statute, partly because not only were there protests going on in the South, but there were boycotts going on in the North. And they sort of calculated that whatever business Woolworth was the main one at the time. I think it's bankrupt now, but they calculated that whatever business they lost from whites in the South, they were going to gain back from both the African Americans in the South and the elimination of the boycotts in the North. So I don't think it was the having two business models that worried them. It was sort of net, they were better off not discriminating.
Hi, I'm Robin Ladd. I'm a 1L. Given the recent Supreme Court decisions to uphold the ban on affirmative action in Michigan and to strike down key parts of the Voting Rights Act, I would like to hear from you all. How do we, go about preventing the dissolution to the solutions to our racial problems?
That's beyond my pay grade.
It's a big question, right? I mean, none of us are going to be able to, in a sense, answer that. I mean, I think one thing I would say, I'm putting on my hat now as one of the problem-solving workshop teachers, is to think about it not just in terms of existing law, but in terms of public opinion and politics. I think, just thinking about getting a statute passed or, amending the Constitution, these are not things that will happen in the next 5 minutes or the next 5 years. And so to me, one thing to think about is a combination of politics and education and that kind of thing. I mean, it's an intractable, not intractable, but it's a really difficult problem that you raise.
My response would be struggle. And there's a struggle to be waged on every front, depending on where you are. And if you're into politics, there's a political struggle. The fact of the matter is that whoever, for instance, is president of the United States is going to determine the ideological complexion of the Supreme Court of the Supreme Court and the federal judiciary. And the personnel of the federal judiciary it matters for all that we're talking about, not only this subject but other subjects. So for everybody in here, there's a struggle on that front. There's a struggle on the educational front. There's struggles on cultural fronts. No matter where you are, there is plenty of work to be done. And I think we're thinking about the Civil Rights Act of 1964. I think at this moment, for people of a certain ideological disposition, there's a certain sort of tendency to be a little bit downhearted, a little bit disappointed, a little bit depressed for some people. I think that now is a perfect time to think back on what things were like before the effective date of the 1964 Civil Rights Act. I mean, I remember, I was a kid, but I remember going from Washington, D.C. to Columbia, South Carolina, where I was born, and for those 8 hours, for any black traveler, you did not know where you could eat. You knew that there were very few places where you could sleep, but you did not know where you could eat. And you did not see, for those 8 hours, you did not see, for instance, a black police officer at all. You were going through enemy territory for 8 straight hours. And black people face that with dread. Now, there's lots of problems in our society, terrible injustices in our society right now. But the fact of the matter is that things are dramatically different now because of the courageous, the intelligent, persistent efforts of, and one could just go, Bayard Rustin, Martin Luther King Jr., Ella Baker, Fannie Lou Hamer. One could go on and on and on and on. So struggle, because struggle matters. And in fact, we are able to see that under some circumstances, changes can be wrought and have been wrought, e.g. the 1964 Civil Rights Act.
Let me just say one more thing. Just adding on to what Professor Kennedy said, I actually really like Professor Singer's introductory remarks, because what Joe said was that public accommodations discrimination is alive and well right here today in Boston. I mean, that comes as a surprise to many, many people. So part of what we need to do is make the case that our civil rights laws still have relevance, that the stuff still goes on. It's not 1964, that's true. When the Supreme Court invalidated the portion of the Voting Rights Act, Chief Justice Roberts famously wrote, "Things have changed dramatically." He's been subject to a lot of criticism for saying that. But there is this idea that we're in a world in which civil rights statutes are no longer necessary. And I think it's really up to all of us to make the claim that, these kinds of things. We're not living in 1964, but discrimination is alive and well in the present, and there's still room for civil rights law.
Good evening, professors. Thank you for being with us and answering our questions. My question is particularly for
What's your name?
Oh, Pamela Nowako, excuse me. My question is for Professor Kennedy, actually. So, Professor Kennedy, you talked about how with the Commerce Clause, we essentially dressed up the law in order to achieve the justice that we seek. And of course, this is in essence hiding our true objectives. So if we want to accomplish racial justice, justice based on sexual orientation, is that what we have to do today?
I'm not sure what we have to do today. I think the point is that different circumstances call for different things. And under certain circumstances, candor is not the way to go. I mean, we, in our day-to-day lives, we sometimes engage in euphemism. We sometimes engage in indirection. We sometimes engage in fictions. What the heck? I mean, you could write a big book. A big book has been written on legal fictions. So sometimes you can't be, sometimes to get where you want to go, you can't get there directly. So one has to show judgment. Sometimes directness is good and required and important, but sometimes not. And, the people in Congress really did, have to grapple with this. Robert F. Kennedy was the Attorney General of the United States and won during the fight over the 1964 Civil Rights Act, and he had to grapple with this. He had to make a decision. And there were some people who said, be straightforward. But his response was, well, I don't know what the Supreme Court's going to do. And do we want to be completely straightforward and then have the Supreme Court essentially ratify the civil rights cases? Or do we want to make this, the Commerce Clause our number one justification and get the Civil Rights Act passed? Well, he chose the latter. I can see the theory behind that. And, that's a matter of political judgment, and, those sorts of judgments will always be with us.
I know you asked Professor Kennedy, but I'd like to say something about that. There's a tendency of lawyers in general, but also Harvard Law professors and Harvard Law students, to focus almost exclusively on federal law. The issue that you're talking about is whether these laws are passed pursuant to the 14th Amendment or the Commerce Clause. When a state passes a public accommodations law, it doesn't need a source. The federal government, Congress has enumerated powers, but state legislatures have plenary power. They have police power. They can pass any law as long as it's conceivably related to a legitimate government interest. These days, everyone would agree that eradicating discrimination in the world of the marketplace is related to a legitimate government interest, probably a compelling government interest, right? So, another strategy that wouldn't require this is to, I'm from New Jersey, and the New Jersey Constitution, so you should read, email me, and the New Jersey Constitution says we are a free and democratic state, right? South African Constitution says open and democratic society. Canada, a free and democratic society. You can pass a state law that says we think people should be able to participate in the marketplace without regard to race. This is a basic function of a democracy. For state law, you don't have this enumerated power thing. You don't have to hide. And one of the, I was saying maybe we need a constitutional right in Mississippi, but I also said I want my students from Mississippi to get that law changed, right? The people in the legislature of Mississippi could change that law. So there's things actually, and the same-sex marriage movement has been a combination of a little bit of the Supreme Court, but mostly state by state by state. Lobbying, people coming out to their friends and family, state litigation, state legislation, state not hiding. So, all right, thank you very much.